Hey guys, thank y'all for joining. Golly, I'm trying to multitask. I said, let me go ahead and get this live out. Go ahead and do my pop in now. And we're going to go ahead and get these court documents. You guys asked me for them, so I have them. And we're going to go ahead and finish that in a second. I'm trying to finish work and get this. So I'm gonna go ahead and read the court documents. You guys can see what we're going to be looking at. You guys asked me for the update for blogger AL and Melody's case. I have that document as well as the court documents for Melody and Martell's custody case. All right, so you guys asked for it and we got it. Okay, ask and you shall receive. So let's go ahead and get into it. All right. Let me put on my good reading skills. Y'all asked me, so we're going to find out from the horse's mouth. We're going to find out from the horse's mouth what had happened over there in the courthouse, okay? Yeah, we got it. So shout out to me. Shout out to my trusted sources as well for helping me get all these documents and shit together and whatnot. So everything said in the video is alleged and in my opinion and is used for fair use and entertainment. Y'all ready for this? All right, so you guys can see here on my thumbnail, you see the thumbnail, and you also see my description says court documents for Melody Sheree versus Martell Holt custody case. And we're going to look at blogger AL versus Melody case update document as well. Okay, so we're going to look at Mel and blogger AL's first, and then we're going to get over to the court document for Mel and Martell. All right, since there's only one document for that one. So let's go ahead and get into it. Y'all want to know, honey? I told you when I get updates, I'll pop right back and give it to you. So I'm gonna go ahead and do that now. Then I'm gonna go ahead and finish up the stuff I got to get done. All right. So I made it huge so you guys can see it. You said, wow, that's back. Yeah, we back. We're back. We're back. We're back. Y'all see it? All right. So electronically filed. 10/20/2025 at 3:55 p.m. Docket number 47-SM-2025-000-241.00. District Court of Madison County, Alabama. Deborah Kaiser is the clerk. Now, in the District Court of Madison County, Alabama, Anthony Lofty's plaintiff versus Rogers Melody Sheree Holt, defendant. Case number, as you guys can see here, SM 2025-000-241-00. All right, let's go on down. Final order, because you know the two of them had to go to court. All right, where Melody was being sued by blogger AL. So it says final order. This matter came before the court on October 20th, 2025 for final hearing. The plaintiff was present pro se. Plaintiff, you guys can see, is blogger AL. Okay. All right. The defendant was present and presented by Kentisha Matthews, Esquire. Based upon careful consideration of the sworn testimony and other evidence presented, the court finds in favor of the defendant on the claims of the plaintiff. The defendant rather is Melody Sheree, so it is fine in favor for the defendant, which is Melody. It says that all other claims not addressed herein are denied. It goes on to say that each party to bear their own costs, meaning court costs, done this day, 20th day of October of 2025. Okay. Linda F. Coates, district judge. All right. So that's the update for that. Okay. You guys can see it here. That's the final order. All right. For blogger Anthony Lofty's versus Melody Sheree Holt. All right. So it looks like Melody the court found her in favor as the defendant that won this particular case. All right. So you guys heard it there. All right. So let's get into the court documents for Melody and Martell. It's 14 pages. So you guys bear with me as I read this. Okay. Oh, hold on. Hold on. Okay, yeah. All right, y'all bear with me as I read because it's 14 pages. So we're going to go through all 14. All right, y'all ready? Put on our good reading skills because it's a lot. Lord, y'all wanted to know, so we're going to know every intricate detail of this case, this court custody case for Mel and Martell. All All right. Wow, that was quick. I told y'all, I told y'all I would pop back once I get the info. All right. So, and a few of you guys asked me, so I always try to give you guys the information y'all asked for. All right. So, document 200 electronically filed 10/20/2025 at 3:02 p.m. Docket number 47-DR-2020-900-543-02, Circuit Court of Madison County, Alabama. Deborah Kaiser is the clerk. Now, in the Circuit Court of Madison County, Alabama, Melody Sheree Holt, plaintiff, versus Martell Holt, which is the defendant. As you guys can see here, that's the case number that we just read. Let's go ahead and continue with the order. All right. This matter came before the court on the 15th day of October 2025 on the plaintiff's verified petition for Rule Nisi and for modification filed by the plaintiff, Melody Sheree Rogers, by and through her attorney of record, Kentisha M. Matthews, and on the answer and counterclaim filed by the defendant, Martel Holt, by and through his attorney of record, Jolene G. Duck. Present for trial was the plaintiff, Melody Sheree Rogers, with her attorney of record, Kentisha M. Matthews, and the guardian ad litem, Valerie Craig. The defendant's attorney of record, Jolene G. Duck, was present, but the defendant, Martel Holt, failed to appear. After taking evidence and testimony, or was it Oritenius, and upon consideration of said pleadings, evidence, and testimony, this court finds that the continuation of the joint custody schedule ordered in the party settlement agreement dated March 21st of 2021 is not in the children's best interest, and further finds that it is in the best interest of the children that the joint custody order be modified as herein set forth. It is therefore ordered, adjudged, and decreed as follows. Let's get into it. Number 1, Melody Sheree Rogers and Martel Holt shall be awarded joint legal custody of the minor children born to the parties, namely to wit, M.S. Holt, born 1/28/12, M.L. Holt II, born 12/19/12, M.S. Holt, born 2/7/2016, and M.S. Holt, 12/19/2019, with Melody Sheree Rogers being awarded the sole physical custody of the minor children and Martel Holt being awarded secondary custodial rights as set out and specified in the court standards visitation and physical custody schedule attached hereto as Exhibit A. Moving down to number 2, it reads, let's move it up. The court standard parenting clauses attached hereto and marked as Exhibit A are incorporated herein by reference and made a part of this decree as if set out in full. Special reference is made to provisions in said standing parenting clauses related to notice requirements of law regarding relocation by either parent as set out in the Alabama Parenting Child Relationship Protection. It gives the order number here, code of it gives the code of Alabama 1975 as amended. Number 3, it is further ordered that the provision for child custody in this decree constitutes a custody decree of custody determination under the Alabama enactment of the Uniform Children Custody Jurisdiction Enforcement Act, and it gives the code as you guys can see there. Number 4, the minor children born to the parties, namely to wit, M.S. Holt, born 1/28/12, M.L. Holt II, born 12/19/12, M.S. Holt 2/7/16, and M.S. Holt 12/19/2019 shall not participate in any television productions or any social media that is for gain/profit without leave of court or until the minor children reach the age of majority. So they still cannot be on TV and or social media according to the court finding. Continuing on. Number 5, the plaintiff, Melody Sheree Rogers, shall be responsible for the guardian ad litem fees. The sum of $1,504.50. Okay, so you guys see it there, is due to the guardian ad litem, Valerie Craig, and shall be paid within 30 days from the date of this order. Number 6, the parties shall continue to use the My Family Wizard to communicate with each other. Number 7, there is no award of child support as no information was provided during the hearing regarding income of either party. Number 8, all other reliefs is hereby denied. Number 9, both parties shall notify with other parent when they are traveling out of town / state during their periods of custody with the minor children to allow the other parent the right of first refusal. Number 10, all other provisions of this court previously ordered, not specifically modified herein, shall remain in full force and effect. Moving along, number 11, the mother's address shall be considered the primary address for school enrollment purposes. Number 12, cost tax is paid. Done this 20th day of October 2025. Allison S. Alton, Circuit Judge. Continuing on, document 200, exhibit custody schedule and parenting clauses of 23rd Judicial Circuit, revised July 1st, 2020. Number 1, custody schedule. Parents are allowed to vary from court-ordered custody schedule by mutual agreement. In fact, the court hopes that parent will be flexible in dealings regarding a child. However, if parents are not both in agreement, the following custody schedule is to be followed. Failure to do so can subject a party to sanctions for contempt of court. B, neither parent has a duty to wait for the other parent for an exchange for more than 45 minutes after the designated start of the parenting time. If a parent does not desire to exercise his or her parenting time awarded herein, he or she shall give 48-hour notice to the other parent. Okay. Shout out to the 290 for watching. D says, unless as authorized set out herein, all visitation will be accomplished by the non-custodial parent picking up the children at the residence of the custodial parent or school if visitation begins at the end of the school day, or such other reasonable places as the parties may mutually agree at the times provided for each period of visitation. The custodial parent shall pick up the children at the end of the non-custodial parent's period of visitation at the residence of the non-custodial parent school if the visitation period ends at the start of the school day, or such other reasonable place as the parties may mutually agree. Continuing on. Both parties shall share their residential address with the other unless leave of court is sought. Visitation is not, however, to be interrupted while such request is pending, and the exchange of the children shall occur at a place mutually agreed by the parties or equal distance from the parties' residence if an agreement cannot be reached. Letter E says that visitation visitation shall be allowed to the other parent in lieu of a child being cared for or on an overnight basis by any persons other than a parent or the parent's spouse. However, a child spending occasional nights with a grandparent shall not be considered a violation of this provision. Okay. F, weekends. Okay. Non-custodial parent first and third weekends of each month from 3:00 p.m. on Friday until 8 a.m. on the following Monday, when the non-custodial parent shall take the children to school or daycare or return the children to the other parent, as the case may be. Fifth weekend, the first and third, fifth weekend of each calendar year from 3:00 p.m. on Friday until 8 a.m. on the following Monday, when the non-custodial parent shall take the children to school or daycare or return the children to the other parent, as the case may be. Okay. Custodial parent, second and fourth weekends of each month from 3:00 p.m. on Friday until 8 a.m. on the following Monday, when the custodial parent shall take the children to school, to daycare, or return the children to the other parent, as the case may be. Fifth weekend, the second and fifth weekend of each calendar year from 3 p.m. on Friday until 8 a.m. on the following Monday, when the custodial parent shall take the children to school or daycare or return the children to the other parent, as the case may be. The first Friday of a new month is deemed by the court to be first weekend of that month. In the event that an other holiday listed below falls on the following Monday, and it is visiting parents' year to exercise such holiday as provided in subparagraph Q says below, the weekend visit shall extend until 8 a.m. on Tuesday. All right. Letter G then reads weekends or weekdays, rather, I'm sorry, every Thursday of each week or another day as mutually agreed by the parties from 3 p.m. until 8 a.m. the next morning, when the non-custodial parent shall take the children to school or daycare or return to the other parent as the case may be. Okay. H then speaks on spring break, spring and fall breaks from school. Spring break says, and even in even numbered years, the non-custodial parent shall have visitation 3 p.m. on the last day of school in session in the district which the children reside, even if the children is or not in school until 6 p.m. on the day before school starts back at the end of spring break, regardless of whether such conflict with other provisions with the custodial parent having the child in odd number years, unless the parties agree otherwise or unless otherwise specifically ordered, where spring break visitation and Easter visitation conflict, spring break visitation will supersede Easter visitation. Fall break. In even number of years, the non-custodial parent shall have visitation from 3 o'clock p.m. on the last day of school in session in the district which the children reside, even if the children is or are not in school until 6 p.m. on the day before school starts back at the end of fall break, regardless of whether such conflicts with the provisions with the custodial parent having the child in odd number years. It is the court's intent that each parent will have one of the school breaks, either breaks, spring break or fall break each school year, and shall alternate with break is to be exercised each school year in the event that the child or children attend school in a system in which both spring and fall breaks are observed. Summer. Letter I, which is summer, says that each parent shall have the children for one half of the summer break from school. In the event the parties cannot agree, summer break for the purpose of this order is from 8 a.m. on Monday following the last day of school until 6 p.m. on the last Friday before school resumes. Non-custodial parent, the first half of the summer break during each even number years and the second half during odd number years. Custodial parent, the first half of the summer break during odd number years and the second half during even number years. Both parents shall continue to exercise their weekend visitation with the number children pursuant the paragraph F above. Okay. Letter J, Easter weekends. In even number years, the non-custodial parent shall have visitation from 3 p.m. on Friday of the weekend in which Easter Sunday falls until 8 a.m. on the Monday following, regardless of whether such conflict with other provisions with the custodial parent having the child in odd number years, unless the parties agree otherwise or unless otherwise specifically ordered, where spring break visitation and Easter visitation conflict. Spring break visitation will supersede Easter visitation. Okay, letter K. Thanksgiving break from school. In odd number years, the non-custodial parent shall have visitation from 3 p.m. on the last day of school before the Thanksgiving school break until 6 p.m. on the Sunday following, regardless of whether such conflict with the other provision with the custodial parent having the child in even numbered years. All right. Christmas break from school. In even numbered years, the non-custodial parent shall have visitation from 9 a.m. on the day after the last day of school before the break until 6 p.m. on December 25th, and in odd number years from 6 p.m. on December 25th until 6 p.m. on the day before school starts back at the end of the break, regardless of whether such conflicts with other provisions with the custodial parent having the child in odd number years from 9 a.m. on the day after the last day of school before the break until 6 p.m. on December 25th, and in even even number years from 6 p.m. on December 25th until 6 p.m. on the day before school starts back at the end of the break, regardless of whether such conflicts with other provisions. Letter M, Father's Day weekend. The father shall have visitation from 3 p.m. on Friday from the weekend in which Father's Day falls until 8 a.m. On Monday after Father's Day, regardless of whether such conflicts with provisions. In the event that the mother is non-custodial parent, the mother shall have the child on the fourth weekend of the month in lieu of third weekend, Father's Day weekend. Mother's Day weekend, the mother shall have visitation from 3 p.m. on Friday of the weekend in which Mother's Day falls until 8 a.m. on the Mother's Day after the Mother's Day, regardless of whether such conflict with other provisions. In the event that mother is the non-custodial parent, the father shall have the child on the third weekend of the month in lieu of second weekend, Mother's Day weekend. Child's birthday, letter O, says that in even numbered years, the non-custodial parent shall have visitation on the child's birthday along with the child's siblings from 3 p.m. to 8 p.m., regardless of whether or whether such conflicts with other provisions with the custodial parent having the child and the child's siblings in odd numbered years from 3 p.m. to 8 p.m. Document 200 continues with letter P, parent's birthday. The parent shall have visitation on the parent's birthday with the child or children from 3 p.m. to 8 p.m. unless said birthday is on a holiday referenced herein. Then the parent shall have visitation with the child or children on another day as agreed to by the parties. Okay. Oh, 432 in the chat. Thank y'all. Letter Q, other holidays. The non-custodial parent shall have visitation from 8 a.m. or if the children is or are in school from 3 p.m. until 8 a.m. the next morning, when the non-custodial parent shall take the children or child to school or daycare or return to the other parent, as the case may be, on the following holidays, with the custodial parent to have the children on said holiday in the years of opposite those years set out for the non-custodial parent, regardless if it conflicts with other provisions. Okay, it then has here number down 1 through 6, Martin Luther King, odd number years. Number 2, National Memorial Day, even number years. 4th of July, odd number years. 4th, which is Labor Day, even number years. Halloween, even number years. Veterans Day, odd number years. Okay, letter R, time out of town vacation. Notwithstanding the foregoing schedule, both parents shall have the right to take the children out of town for a vacation for a period of time not to exceed 10 consecutive days, during which time the other parent shall not have the visitation/joint custody time otherwise provided for above. The vacation period to be exercised by the custodial parent shall not be allowed during the non-custodial parent's summer, school breaks, special occasion, or holiday periods of visitation. Likewise, the non-custodial parent's out-of-town vacation period shall be scheduled during his or her exercise summer period of visitation and shall not be allowed during the custodial parent's school break, special occasion, or holiday periods with the children, school break, spring vacation, fall school break, as specified above. Okay, holidays, Christmas, Thanksgiving, school breaks, Easter weekend, other school holidays as specified above, special occasion, child or children's birthday, and Mother's Day weekend, Father's Day weekend. It says that when the vacation falls on a weeknight or weekend, when the children or child would normally be or not be with the parent who wishes to take them out of town on vacation, the parent shall attempt to agree to switch weekends or weeknights or weekends, as the case may be. If the parent cannot otherwise agree, the makeup time shall be in equal number of days as those used and shall be made up during the next time the child or children are scheduled to be with the parent requesting the out-of-town vacation time. Letter S, special family events. Each parent shall have the child or children with him or her for special family events such as weddings, funerals, and reunions, which pertain to members of the parent's immediate family, parents, grandparents, siblings, and or other children, provided, however, that no such period shall, without the other parent prior consent, interfere with or deprive a parent of his or her holiday, school break, special occasion, or out-of-town vacation periods with the child or children. School break, spring vacation, fall school breaks as specified above, holidays, Christmas, Thanksgiving, school breaks, Easter weekend, other school holidays as specified above, special occasion, children's birthday, Mother's Day weekend, Father's Day weekend, parents' birthday. Okay. The parents seeking to have the children or child with him or her for the special family event shall provide as much advance notice to the other parent as possible. When the event falls on a weeknight or weekend with the children, would normally not be the parent who wishes to take them to the special event. The parent shall attempt to agree to switch weekends or nights, okay, weeknights, as the case may be. If the parent cannot otherwise agree, the makeup time shall be the next following weekend if a weeknight is missed, or weekend if weekend time is missed. Letter T, in the event the parent who does not reside with the children lives more than 150 miles from Madison County, Alabama, the court standard 150 miles visitation schedule shall apply. Parenting clause number 2, letter A, both parties shall have reasonable telephone access to the minor children while they are in physical control of the other parent. The minor children shall also have reasonable telephone access to both parents during a 1-hour time period as agreed upon by the parties, taking into consideration the children's schedule. If a conflict develops regarding phone time, it shall be nightly between 7 p.m. and 8 p.m. Okay, B, at all times thereafter, each parent shall keep the other informed of the prospective or respective business, cellular and home telephone numbers and their respective street address, mailing addresses, and electronic mail address unless leave of court is granted. Both parties will make themselves available for direct communication with the other for the purposes of discussions pertaining to the minor children, provided, however, neither parent will harass or burden the other with excessive or abusive telephone calls, Martel, okay, or other such non-productive communication. Further, both parents shall refrain from delegating their responsibility of communicating with the other parent to third parties, Ariane, except in bona fide emergencies, and will at reasonable times and places make themselves available to communicate directly with the other parent pertaining to the needs and interests of the children. If agreed upon by both parents, electronic mail services such as the Wizard or Google Calendar may be used to track communications and share appointments and events between parents. Letter C, the parties shall promptly notify each other in the event of serious illness or injury of the minor children. D, both parents shall encourage the minor children to love, respect, and honor the other parent. Neither of them shall alienate or attempt to alienate or diminish the affection of the minor children or for rather the other parent, or disparage or allow others to disparage the other parent to or in the presence of the minor children. The parties understand and agree that the designation of father and mother or similar designation shall refer to each of them only and not to third parties. Okay, letter E. The court expects children to be insulated to the fullest extent possible from the conflict between their parents. They should not be made to be confidants of parents and should be encouraged to love, honor, and respect both parents and their respective families. Parents should act accordingly in the presence of the children. In the event a child testifies in court, a parent shall not question or discuss that child's testimony with the child, nor discuss the case with the child. I agree. Letter F, neither parent shall schedule activities for the minor children for the purpose of precluding the other from having the minor children with him or her at the times and places set forth therein. In the event a parent believes that it is beneficial to the child to schedule activities for a minor child that take place over both parties' time with the minor children, the parties shall jointly confer and attempt to make the joint decision in the best interest of the children concerning those activities. In the event the parties are unable to reach an agreement, the custodial parent and or the parent having primary authority and responsibility over the area of decision making pursuant to the court's order shall make the final decision. It shall be the responsibility of the parent who has the children during the activity to provide transportation for the minor children to those activities to the extent possible. In the event that it is not possible for a parent who did not make the decision to schedule the children for the activity to provide transportation for the children to the activity during his or her time, then the parent who make the decision to enroll the child in the activity shall be responsible for providing the children transportation to and from the activity. All right. Shout out to the 494 watching. The court will take a very conservative stance on extracurricular activities and the reimbursement of same. While these activities are beneficial to the child, in most cases, these decisions must be based on the reasonableness of the cost and each party's ability to afford the same. Okay, letter G, both parents shall have equal access to all information concerning the children, including but not limited to medical, dental, and hospital records, school records, report cards, recreational activity records, and other information concerning the minor children. Both parents are to be listed as emergency contacts. If information is available online, the parents shall provide each other with the information necessary to establish a username and password for school and extracurricular activities, which use online communication as the means of communicating with the parent. In the event that the only paper communication is available, a duplicate notification cannot be obtained through the school. Should either parent receive a school calendar, parent-teacher conference notice, and or report card of the children, the parent receiving such shall provide the other parent with a copy, therefore, immediately. In the event that a parent enrolls a child in a sporting or extracurricular activity, the parent shall provide the same information with regard to the other parent that the parent provides regarding himself or herself. All right, down to letter H. Each parent shall provide the minor children with clothing and basic necessities during his or her custodial periods and return to the other parent any items of clothing provided by the other parent. The party shall cooperate to allow the children to transport between households any items necessary for school and or activities, including school books, uniforms, sporting equipment, etc. Letter I, the party in whose care the minor children are then being kept shall be authorized to make and decide medical emergency decisions concerning said minor children. In the event such an emergency medical decision should arise, the party then in physical custody of the children shall notify the consult the other party as time may reasonably allow governing any such emergency. Letter J, neither party shall use illegal drugs, prescription drugs not as prescribed, nor be impaired by the use of alcohol during any time that a child of the party is in his or her care. Letter K, during any periods of overnight visitation and or exercise of custody with the party's minor children, neither party shall allow any person to whom he or she is not related by blood marriage and with whom he or she is not involved in a romantic or incestual relationship to stay overnight in the same place with the party's children. Ariane. All right. So Ariane cannot spend the night when the children are there. Letter I then says, letter L, the court expects both parents to have the opportunity to attend a child's medical and or dental appointments, as well as the child's school or extracurricular activities, including a parent-teacher conference, school events, sporting events, etc. A parent scheduling any such appointments or receiving notices of such activities should give the same notice to the other parent as soon as received. Parents shall conduct themselves in a civil and appropriate manner at all such appointments and activities. Contact by the child and both parents at any such activities is encouraged and should be allowed. Letter M, unless otherwise specifically ordered, a parent shall be allowed to eat lunch with a child at school, provided, however, that all applicable school rules and requirements shall be followed. Letter N, the parent exercising custody shall be responsible for making sure the children does homework, studies for any test and is otherwise prepared for school the next day, and shall be responsible for getting the children to school on time with whatever the children's needs for that school day, including but not limited to lunch. Letter O, it is the desire of the court that both parents work together to ensure that the child grows up as happy and well-adjusted as possible. It is important to the court that a child of divorced parents is made to feel and understand that the divorce is not the child's fault, that just because the parents are divorcing, they are not divorcing the child, that the child has a lot of people who love the child, and that even though the parents will be living in separate homes, the child is still a part of a family. Document 200 continues, letter P. A child shall not delegate his or her responsibility. A parent shall not delegate his or her responsibilities for communicating or communication with the other parent to a spouse of a parent or any other person unless both parties agree to communicate through the spouse or other person. A parent shall treat the spouse of a parent with the same civility and respect herein request of a parent, provided, however, a spouse of a parent shall not attempt to interfere in communications or dealings between a child's parent. It says that a child shall be taught and encouraged by both parents to show respect to a spouse of a parent. Okay. Alabama law requires each party in this action who has either custody or the right of visitation with the child to notify the other parties who have custody of or the right of visitation with the child to any change in his or her address or telephone number or both, and of any change or proposed change of principal residence and telephone numbers of a child. This is a continuing duty and remains in effect as to each child, subject to the custody and visitation provision of this decree until such child reaches the age of majority or becomes emancipated, or for as long as you are entitled to custody or visitation with the child covered by this order. If there is a change of principal residence by you or by a child subject to the custody or visitation provisions of this order, you must provide the following information to each other's person who has custody or visitation rights under this degree as follow. Letter A, the extended new address, including the specific street address if known. Letter B, the mailing address if not the same as the street address. Okay, it continues the telephone number or numbers at such address or residence if known. D then says, if applicable, the name, address, and telephone number of the school to be attended by a child if known. Letter E then goes on to say that the date of the intended address of principal residence of a child. Letter F, a statement of the specific reason for the proposed change of principal residence of a child, if applicable. Letter G, a proposal for a revised schedule of custody of or visitation with a child, if any. Letter H, unless you are a member of the armed forces of the United States of America and are being transferred or relocated to a non-voluntary order of the government, a warning to the non-relocating person that an objection to the relocation must be made within 30 days of receipt of the notice, or the relocation be permitted. Continuing, it said you must give notice by certified mail of the proposed change of principal residence on or before the 45th day before a proposed change of principal residence. If you do not know and cannot reasonably become aware of such information in sufficient time to provide a 45-day notice, you must give such notice by certified mail no later than the 10th day after the date that you obtain such information. Continuing, your failure to notify other parties entitled to notice of your intent to change the principal residence of a child may be taken into account in a modification of the custody or visitation with a child. If you, as the non-relocating party, do not commence in action seeking a temporary or permanent order to prevent the change of principal residence of a child within 30 days after receipt of notice of the intent to change the principal residence of a child, the change of principal residence is authorized. Okay, so that's 14 of 14. We got through that quick. Thank God for some good reading skills. So those are the court documents of Melody and Martell's child custody arrangement that they just had in court, you guys. Okay, so I hope you guys were able to understand that. It's pretty much to the T in terms of how they should follow the court's demands in terms of how the visitation and everything should work out. You guys see that here. Again, it was electronically filed 10/20/2025 at 3:02 p.m. In the circuit court of Madison County, Alabama. Melody Sheree Holt, which is the plaintiff, versus Martell Holt, which is the defendant. And that is the order for them. Okay, so thank you guys so much for joining me for this read of the court documents. Please don't forget to tap on that like button. Shout out to the 597 watching. Please do not forget to tap on that like button. And also subscribe to the channel if you've not done so. As you guys can see, we are starting to read court documents and stuff over here now, as well as you guys request them. We'll dig those up and read them for you guys. Okay. And also we did just talk about the court document for blogger AL versus Melody Sheree. I'll put that back up for you guys so y'all can see that as well before we get out of here. For those of you joining just now. Okay. As you guys can see here, document 41. Electronically filed 10/20/2025 at 3:55 p.m. That's the docket number there in the District Court of Madison County, Alabama. Anthony Lofties is the plaintiff versus Melody Sheree Holt Rogers. That's the case number there, SM-2025-000-241-00. That's the final order here. I'll read it one more time for you guys, for you just joining. In the matter came before the court on October 20th of 2025 for a final hearing. The plaintiff was present pro se. Plaintiff, as you guys can see, is Anthony Lofties. The defendant was present and presented by Kentisha Matthews. Thank you so much, Cassandra D, for the $10 super sticker. The plaintiff was pro se. The defendant was presented by Kentisha Matthews, Esquire. Based upon careful consideration of the sworn testimony and other evidence presented, the court finds in favor of the defendant, which is Melody Sheree Rogers, on the claims of the plaintiff. Okay, all other claims not addressed herein are denied each party to bear their own costs, meaning court costs, done this 20th day of October of 2025, signed off on Linda F. Coates, which is the district judge. All right, so that is it, and that is all. We have the court documents, as you guys can see, for blogger AL and Melody Sheree Rogers court case, which was on yesterday, and also Melody Sheree and Martell Holt, the child custody court documents as well. So you guys saw that, we read that, we gave you guys the update, and that is it, and that is all. Gotta go, guys. All right. I'm pushing my stuff back. So thank y'all for joining. All right. Thank you to my Top Flight Mosh, True TV Podcast, Tyra, KBR, Sweet Essence, Scorpion Miss, Rose Armstead. Also, thank you to all the content creators that dropped in today to support the video as well. Let me get back to my main screen. Love you guys down. Thank you so much, Cassandra D, for the $10 super sticker. Thank you guys for all of the likes that you guys gave for the video as well. All right. Thank you guys for stopping by, all my Caramelians. Love you guys down. Enjoy your day. I will see you guys again for another pop in later on. I got to get my work done to get caught up because I wanted to go ahead and give you guys these court documents. Love you guys down until the next video. See you guys later. Bye.
person that